Hi there. My name is Paul Campbell, and I'm going to finish reading You Know Something is Wrong When, an American Affidavit of Probable Cause. The final chapter that we are going to read today is Part 12, J'accuse, the Formal Affidavit. J'accuse, Affidavit of Probable Cause. We, the affiants, a living man known to the public as James Clinton Belcher, and a living woman known to the public as Anna Maria Riesinger, free-born on the land jurisdiction of the United States of America, known as the continental United States, are able and competent and of age to present ourselves in the flesh and bring forth this affidavit in our own behalf, and that of all the others similarly abused and affirm it as the truth from without the federal United States. We have first-hand experience and knowledge of the circumstances herein described and are also enabled via the last one of the several states on the land owed the Alaska Statehood Compact, the Wisconsin state, and the Washington state, which are birthright, and we do not present our claims without representation of any kind and any without any purpose of evasion or deceit, and do depose the following. 1. We say that the preceding 101 items cataloged in the table of contents of this bound and sealed documents presented the verifiable history and facts necessary to a certain reasonable and probable cause of this action, and claim and does justify the establishment of public lien favoring the Alaska state and the people inhabiting Alaska, and upon all actual property assets owned, claimed, indebted, securitized, or bounded by the now defunct United States of America Incorporated and its States of Alaska franchise, also the United States Incorporated and its States of Alaska Incorporated franchise and the United Nations Incorporated and its Alaska franchise, and any other so-called state corporation established under the provisions of the Uniform Commercial Code. We likewise affirm that similar public lien and interest is owed to all the actual 50 states of the land jurisdiction belonging to the States of America and the United Colonies of America, such as the Wisconsin state and the Washington state, and the people inhabiting the land thereof. This is important because without a thorough and fairly detailed grasp of the history and public records and issues of public interest involved, it is impossible to understand the basis and necessity of the public lien being established. We say that the lawful government owed to our nation by the unum sanctum global estate trust and our international trustees, including the rector and the National Shrine in Washington, D.C., who is supposed to govern and safeguard our portion of the global jurisdiction of the air, and the United States Postmaster, who is supposed to govern and safeguard our national jurisdiction of the land, and the British monarch entrusted with governing safeguarding Americans and American vessels operating in the international jurisdiction of the sea, has been purposely usurped by those trustees and by international banking cartels operating deceptively named governmental services corporations, as if these private-owned for-profit legal fiction entities were in fact the actual government, and as if they were in fact in receipt of our granted authority and lawfully enabled to act as our deputies. This is important because this mammoth breach of trust has given rise to the fraud schemes and other criminality Karen discussed, and also to our material claims and requests for permanent protective injunctions, safeguarding the interest of all those affected. We say that we and our parents and our grandparents and our children and grandchildren of all our estates and land and businesses and homes together with our bodies and labor and other natural resources and assets, both material and immaterial, including our most fundamental natural rights, has been plundered and harmed as a result of the history and facts presented herein. This is important because as our individual estates have been commandeered and plundered, the welfare of the entire planet has suffered as a whole. It is also important to establish our own standing as injured parties. We have been misrepresented and denied remedy, due and most recently extorted and threatened at gunpoint. We say that we have been misrepresented and mischaracterized and defrauded by people and by institutions, including foreign governments and banks and governmental services corporations that owe us friendship and support and good faith service. Those who have assaulted and press ganged us into the foreign international jurisdiction of the sea were successors to contracts including solemn trust indentures and international treaties and commercial service contracts, including the Treaty of Paris, 1783, the Treaty of Versailles, 1784, the Treaty of Westminster, 1794, the Supreme Perfected Declaration of the United Colonies of America, 1787, the Constitution for the United States of America, 1789, and various trade and defense and mutual support agreements since then, too numerous to list. This is important. This is important because we have good cause to trust the offenders and to rely upon their goodwill, honesty, and intent. We say that we have suffered personage and barratry and unprovoked attack from the members of the American Bar Association, which has acted in the role of an organization crime syndicate and operated private so-called administrative courts, which are corporate tribunals, as if they were public courts, and have used some semantic deceit as a means to promulgate this fraud and deception upon the American people. The membership of the American Bar Association has preyed upon the people of our country in the guise of undeclared foreign agents and inland pirates seeking the overthrow of the land jurisdiction of the continental United States and in defiance of the Constitution for the United States of America and in breach of the treaty allowing for the United States of America and in breach of the treaty allowing their presence on our shores. They have also breached their Bar Association charter by mischaracterizing living Americans as mental incompetents and wards of the state and federal employees as in various other false personas. This is important because it shows a widespread pattern of willful and purposeful abuse that cannot be explained away as the result of individual ignorance or lax procedure. And because the members of the bar associations cannot be presumed to be acting in ignorance of their own charter and treaty, much less requirements, the basic requirements of the Constitution governing land jurisdiction of the law of continental United States and the public law. We say the government of France, doing business as France, has colluded with the city-state of Westminster and inner city of London, doing business as Westminster, and as Elizabeth II, and as the Crown Corporation, and has harbored and incorporated and protected other crime syndicate organizations, including the United Nations Incorporated, so as to expedite and aid and abet the crimes of these corporations against Americans and Australians and Scots and Irish and Canadian and other people of the former Commonwealth nations, and most of the other nations of Western Europe, and the contravention of international treaties, corporate charters, trustee relationships, and other obligations. This is important because the cooperation of these governmental services corporations in establishing private business entities in foreign jurisdictions and then using them to carry out undisclosed predatory actions in other countries shows a pattern of deceit and intent to avoid detection of their actual identities and purpose. We say the government of the United Kingdom and the Lord Mayor of London and the temporal office of Her Royal Majesty Queen Elizabeth II, doing business as Elizabeth II, and most especially the Lords of the Admiralty, have promoted and perpetuated false claims via fraud and the repugnant and unlawful practices of usury and press ganging and inland piracy, resulting in the enslavement of landsmen in the foreign jurisdiction of the sea. Successive British monarchs, Lord Mayors, and Lords of the Admiralty have allowed these attacks upon peaceful neighbors and former colonies and allies, and have been instrumental in promoting the destruction of the peace and economic well-being and private property rights of at least one half of the living people worldwide, including ourselves. This is important because it demonstrates long-term and purposeful and self-interested criminality on the part of the government of the United Kingdom, the city-state of Westminster, and the Crown. These institutions and officials have been in control of and responsible for administering the international jurisdiction of the sea for centuries and cannot be presumed to be ignorant of their duty nor of the laws of admiralty, which have reconsidered press ganging and inland piracy as capital offenses for 200 years. We say that the United Nations city-state, which was given land and sanctuary upon our shores and supported primarily with our labor and resources since its charter was signed, has shielded the perpetrators of the vast crimes revealed herein, and that the United Nations Incorporated has profited from and given aid and assistance to individuals and organizations known to be criminals, including the Federal Reserve banks doing business as the Federal Reserve, which has been given sanctuary and charter under United Nations city, state, and United Nations Incorporated auspices. This is important because we and many other people worldwide have trusted the United Nations to function as a bastion against criminality and violence, and it has instead aided and abetted these activities. We say that the Swiss government is also culpable for harboring, aiding, and abetting known international crime syndicates, including the perpetrators of the 1930 and 1933 bankruptcy debacles, including the World Bank and Bank of International Settlements and Federal Reserve Banks and the International Bank of Reconstruction and Development, which have all taken profit and advantage from the destruction of war and the pillaging of innocent people's private property. This is important because the Swiss government and the Swiss banking industry have been respected worldwide for centuries for their expertise and high ethical and professional standards. Their failure to address the perpetrators of bankruptcy fraud and securities fraud on such a massive scale again demonstrates a pattern of willful deceit and collusion that can not be explained away on the basis of ignorance or inadequate procedure. We say that the United States Incorporated, operated by the International Monetary Fund Incorporated, and its incorporated states with state franchises doing business under names like the state of Ohio, have operated a confidence racket and fraud and enslavement scheme of unimaginable proportions and imposed it by force and extortion upon the innocent and trusting American people, including a bait and switch sales of land transferred into lessons of real estate. You don't know. Bait and switch sales of land transformed into leases of real estate. Imposition of land titles held by the United States and its state franchises under color of law. The United States has promoted multiple Ponzi scheme fiat monetary systems imposed in breach of contract and trust upon the American state citizens. The United States has operated reverse trust schemes against the states of individual living Americans. The United States has abused of the rights of usufruct and has employed them against the American people and their private and public property assets. The United States has committed unlawful conversion of American assets carried out by systematic entrapment and probate fraud exercised by semantic deceit and non-disclosure. The United States has forced sales of United States corporate services under the false pretense that receipt of these services of enrollment in these so-called benefit programs was mandated by the lawful American government. The United States has routinely and self-interestedly kidnapped individual Americans into the foreign jurisdiction of international commerce and maritime law and subjected them without granted authority. The United States has made false claims of contract and capacity to lawfully represent these same Americans. The United States has deprived Americans of access to common law courts guaranteed to them under commercial contract and international treaty. The United States has mercilessly plundered the national trust assets of our people and nations and profited itself from war and prison industries and the promotion of drugs and prostitution and arms sales and sale of alcohol and contraband and vice of every possible description. The United States has approved unimaginably large sums to operate from the public purse for people and purposes such as international relief efforts, resources that have instead been siphoned off by criminals and political cronies and never reach their purported destinations. The United States has served as a vehicle to spread war for profit throughout the world, and both by act and omission has served to create endless war and conflict. The United States has lied insistently to the American people and carried out sophisticated and unprincipled propaganda campaigns designed to make them believe that slavery is freedom, poverty is wealth, and predation upon private assets is the price of being kept safe from false flag attacks carried out by the perpetrators against the American people. The United States has knowingly promoted fake and politicalized scientific data and promoted scientific theories known to be false in a prolonged effort to justify taxation to further enrich itself. The United States has recklessly pursued the destruction of the American dollar's reputation and value by substituting US dollars in Federal Reserve notes and petrodollar exchanges for American money and reserve notes and petrodollar exchanges for American money and biking the entire unsuspected world. The United States has established oppressive and unlawful monopolies and self-interested regulatory controls upon basic commodities and services. The United States has openly practiced peonage, press ganging, and enslavement, including enforced registration for selective service, and has used criminalization of basic natural rights as the means to implement its control of the bodies and minds of individual American state citizens. The United States has pursued additional forced registration of many private property assets, including automobiles and livestock, and even activities such as operating machinery so as to claim false ownership and controlling interest in these assets and activities as a basis to raise ongoing revenue and hypothecate more debt against the American people and their private property. The United States has never fully disclosed its nature or current charter or actual shareholders and other information necessary for it to form valid contracts of any kind with American state citizens, nor the continental states. The United States failed to retool for peacetime trade after World War II and has continued to export implements and commodities of war as its primary export products, which has led to promoting war for profit and to unnecessary widespread unemployment and poverty. The United States has suppressed many basic elements of education, leaving American students in free fall and at the mercy of whatever ignorance is profitable for the United States. The United States has deregulated banking and encouraged lawfulness and secured in the securities markets of the nation and the world. The United States has failed to honor virtually all publicity stated publicly stated remedies that the United States has agreed to in the past, including the payment of interest on investments and access to the credit owed to individual living people. The United States has obligated to the American people to numerous trade and treaty agreements which openly victimize them and plunder their assets for little or no equitable consideration in return. The United States has acted as a criminal syndicate for decades and has misused the trust of the American people and their assets to wage war and genocide against other nations throughout the world. We say that the United States and its parent corporation, the IMF, deserve to be liquidated and that their joint assets must be returned to the rightful entitlement holders, and their profits must be distributed to their priority creditors. This is important because without a widespread and public recognition of the evil done by these corporations and an equally public repudiation of their criminality, it is impossible to sustain any basis for trust, trade, or public law. We say that the former Federal Reserve System and the current Federal Reserve and its respective front organization doing business as the United States of America Incorporated and the United States of America Incorporated are guilty of all the same crimes in the United States cited as A to Z above, plus they bear the additional onus of being the original perpetrators of this criminality. These organizations and their bank sponsors are responsible for redefining criminals as slaves and enshrining the practice of slavery and for the promotion of prison industries and the misuse of commercial penal bonds as a means of enriching the member banks supporting the associated front organizations pretending to be successive national governments representing the American people. Enriching the member banks supporting the associated front organizations pretending to be successive national governments representing the American people. We say that the United States of America Incorporated has already been shut down and its assets redistributed to other corporate entities with which is acted in collusion to siphon off the assets and profit owed to the American people, and that the credit and the interest owed to the American people and mischaracterized as the national debt has been handed off to the Internal Revenue Service, United States Department of Defense, Finance and Accounting Services, and the North American Water and Power Alliance. We say that these organizations have been used to be received the purloined principal and profits owed to be the American people by the Federal Reserve System under the false pretense that they represent the American people as fiduciaries, and that in fact they have misappropriated credit the credit and funds under distribution to spawn another private fiat monetary system and continue the enslavement and purposely mischaracterization of the American people and the continental United States. This is important because it demonstrates again a purposeful and long-term and malice collusion to deceive and deprive the priority creditors of both the Federal Reserve System and the IMF. We say that these incorporated organizations have been misused to convey stolen assets and promote misappropriation of public and private trust funds, and that they must be liquidated and the credit and assets that have been purloined must be returned to the American people and the American states on the land as the priority creditors, and that the American people are owed all good faith vested in the global estate trust and the other nations of the world to come to their assistance and help them bring an end to this fraud which has engulfed the whole world. This is important because the criminality of these banks and the governmental services corporations these banks have employed as fronts has extended tentacles to the farthest reaches of the globe. Such vast criminality cannot be defeated by the efforts of 1, 10, or 20 nations. The history of the United States exposed by this affidavit has been replicated as if from a common playbook in country after country throughout the world, and it has had the same results that must be addressed as a global community and resolved in favor of the living people. We say that the only valid equity contract existing between any of the several continental states and the federal United States is the original equity contract known as the Constitution for the United States of America, and that no authorized deputies of ours have created or contributed to this criminality. Far from being complicit or authorizing this behavior on the part of the federal United States, we peaceful inhabitants of the continental United States have been outrageously harmed and abused as a result of British mismanagement of the federal United States. This is important because the people of the continental United States and the actual states of the land jurisdiction have not benefited from nor have we authorized the criminal activities of the federal United States and its corporate and municipal franchises. We have been victims along with the rest of the world as malfeasance and fiduciary trust fraud on an unimaginable scale. We say that in addition to all the material damage and harm to the American people and the American states on the land, our reputation among the other nations of the world has been all but destroyed by the British controlled federal United States and their endless war profiting. This is important because while the American people and the continental United States has been at peace for 150 years, the rest of the world wrongly blames us as the source of this criminality and warmongering. We say that our honorable American dollar, defined as fine silver and issued by the continental United States, has been deliberately confused via semantic deceits with United States dollars, and the value thought to be vested in these United States dollars, represented by Federal Reserve notes, has been devalued by more than 98% by the perpetrators of this gigantic fraud. This is important because the reckless devaluation of our currency is the direct result of criminal usurpation, usurpation and fiduciary trust fraud on the part of the federal United States and international banking cartels. We say that these foreign commercial corporations, including banks and their governmental services corporations, and all their franchises do not now and have never in the past functioned as our lawful government, and they do not represent us. This is important because until other people in other nations around the world clearly grasp the enormity of the crimes perpetuated upon us all by those under contract to serve us, we will continue to blame each other instead of rooting out the criminals and imposters responsible. We say that these foreign corporations are merely under commercial contract to provide 19 stipulated services known as enumerated powers, and that their claims to the beneficiaries of the continental United States and the American state citizens of the land are criminal usurpation and fraud against their employees. This is important because per- perpetrators the perpetrators already pulled this once during the 1930s, and they are attempting to go forward and do it again. We say that these foreign corporations, banks, and governmental service corporations and franchises and agencies of these entities have run amok, and that those responsible for their misadministration have been given due notice and process by American state citizens and the continental United States without appropriate remedy. This is important because we have shown good faith and due diligence and have given these corporations and their managers ample and appropriate due process and opportunity to correct their operations and provide remedy without result. We say that misadministration of the international jurisdiction of the sea has been the means to all these evil ends. Her Royal Majesty Elizabeth II and her predecessors and the Lords of the Admiralty and the Lord Mayor of London and their predecessors have, by both action and omission, betrayed their sacred trust and have been in breach of trust with respect to the United States Trust, the United Colonies of America, and the continental United States for 150 years. This is important because the longevity of the fraud demonstrates its nature and intent as a conscious long-term violation of international treaties and commercial contracts for a century and a half. We say that similar misadministration by the British monarchs and the Lords of the Admiralty and the Lord Mayor of London have resulted in similar betrayal and breach of trust against the nations of the former Commonwealth, Japan, and most of the nations of Europe. This is important because it demonstrates that the purposeful promulgation of this fraud is not any oddity or peculiarity of the British-American relationship, but is rather an international conspiracy to control and defraud and subject entire nations. We say that insomuch as the Holy See has declared and endeavored to build a global estate trust per the claims issued as the Unum Sanctum Romanus Pontifex, Attorney Regis, and Convocation of 1537, and has included all nations within that trust and striven to establish the jurisdictions of the air, land, and sea, and to establish common governmental services available to all. The Holy See is obligated to obtain peaceful resolution of our claims and enforce the return of our private property assets. This is important because without prompt action by the Holy See to correct and halt this systematic fraud against the living people, the Global Estate Trust will also stand in breach of trust. We say that insomuch was the Holy See and the Vatican have been instrumental in converting almost all national governments on earth into national corporations operated in the international jurisdiction of the sea, and the Roman Curia has created the law forms giving rise to incorporated legal fiction entities. It is the unique responsibility of the Holy See and of Pope Francis doing business as Franciscus to correct the breach of trust and the mismanagement of these corporations. This is important because the Holy See and the Roman Curia have created all the various forms of corporations, trust, public utilities, and so on, and they remain responsible for what they created by maxim of law. We say that in accord with the published law of the air jurisdiction of the Global Estate Trust, we individual affiants have acted within the law of love and have respected the free will of other people and kept the peace despite being criminally presumed upon and attacked by corporate entities that are supposed to be providing us with governmental services under contract. This is important because it is first-hand confirmation that non-combatant civilians who are in fact priority creditors of the bank and the governmental services corporations involved, living people who are owed protected person standing, have been deliberately mischaracterized and subjected to attack. We say that our employees and debtors have attempted to kidnap and extort property from us despite being given fair notice and offered sufficient proof of our identity. This is important because employees who do not obey their employers are insubordinate, and debtors who attack their creditors are clearly criminals subject to arrest and prosecution. Yet nothing was done to correct this circumstance by the local franchise of the United States doing business as the state of Alaska, and no action was taken by the Alaska court system nor the British High Court to discipline and properly inform the Airing Bar Association members. We say that the Federal Reserve, the United States Incorporated, the United States of America Incorporated, the United Nations Incorporated, and their agents and franchises have presumed upon us, their employers, clients, and benefactors, and have acted as criminals in our midst and in violation of their charters. This is important because it is good and sufficient reason to find, discipline, or liquidate these corporations and their offending franchises and to prosecute the offering employees. We say that we and our parents and our grandparents never authorized any change of our birthright status as American state citizens born on the land as peaceful co-inhabitants of the continental United States, and according to no less than three public declarations by President Andrew Johnson, our nation has been at peace for 150 years. This is important because it demonstrates that the absurdity of claiming that we are combatants in any kind of war, that we are enemies of any state or subject to any foreign military law. If our birthright status has been changed by any nation at war, it is proof of violation of the Geneva Convention Protocols of 1949, Volume 2, Article 3, and prima facie evidence of a capital crime having been committed by agents of the IMF and the United States and their franchises under cover of martial law. We say that we never authorized anyone to offer us or our credit or any asset of our private estates as surety for the debts of any governmental services corporation whatsoever, and we did not take any sides or participate in any war, and we do not recognize any right of conquest related to us and our property. This is important because those responsible for the fraud described by this affidavit have attempted to claim that they are at war and to use this as an excuse for their criminality against their employers and priority creditors. No corporation on earth has authority to declare war and therefore has no legitimate claim upon the laws of war, nor the law of nations. These are merely criminal commercial syndicates engaged in unlawful mercenary and police actions, and their attempted recourse to any form of martial law or right of conquest claim is more prima facie evidence of criminal wrongdoing. We say that we never authorized anyone to enter our states into commerce, nor to incorporate or enfranchise or probate them, and that the existence of entities constructed as trust named in the form Anna Maria Riesinger and James Clinton Belcher, or transmitting utilities named in the form Anna M. Riesinger and James C. Belcher, are entirely the unauthorized acts of individuals and organizations claiming to be usufructs, benefiting from the existence of these legal fictions. As such, they are morally, and as fiduciaries, completely responsible for all expenses and charges related to these legal fiction entities by maxim of law. They are responsible for what they create. This is important because the modus operandi of these criminal banking cartels and their governmental services corporations to pretend that the living people are responsible for paying the debts of legal fiction personas that are merely named after them, when in fact the banks and governmental services corporations that create these deceptively named trusts and transmitting utilities are responsible for all debts, fees, expenses, etc. related to these legal fictions. Charges brought against these legal fictions yet addressed to the living people of the same name is prima facie proof of attempted personage and mail fraud. We say that we did not undergo the process mandate. We say that we did not undergo the process mandated by two statutes at large, 153, Chapter 28, subsection 1, revised statute states citizenship revised 2561, which is required for American state citizens to adopt United States citizenship, and any claim otherwise is false. This is important because the statute at large requires that we cannot be alienated from the land jurisdiction of the continental United States by any private contract. The absence of public due process and recording by competent adults is prima facie evidence in negative averment that no valid change of status from American state citizen to United States citizen has taken place. We say that we have never considered federal United States citizenship to be beneficial in any way, and that as American state citizens, we and our brethren are owed all material interest vested in the national trust owed to the United Colonies of America and the continental United States, including all interest in our land and its resources, all rights and prerogatives guaranteed to us by birthright, plus all insurance policies, premiums, interest, dividends, stocks, credits, bank accounts, mortgages, promissory notes, bonds, and other securities that we either paid for directly with our labor or which were created under conditions of non-disclosed contract, semantic deceit, and other fraud, and which were issued against our assets under false pretense by foreign governments and governmental services corporations. This is important because we are owed lawful claim to all assets naturally belonging to us and to the land jurisdiction of the continental United States. As the entitlement holders of the assets, we are owed their return free and clear of authorization by authorized secondary beneficiary debts and encumbrances. We say that any presumption that we knowingly and willingly donated our life savings, retirement accounts, bank accounts, homes, businesses, or any other material assets held in our names to benefit any incorporated entity is insupportable. This is important because plausible motivation to donate our assets is lacking. There's no actual and equitable benefit to us from any registration or enrollment or application process foisted off on us under the false pretense of it being a government mandate. We say that the improperly seated and incorporated 39th and 40th United States Congress created incorporated states of states merely named after the actual organic states of the Union. State of Michigan and state of Ohio and states of Florida were merely named after the Michigan state, Ohio state, and Florida state. This is important because this semantic deceit was used to defraud and confuse people and as a device to force American state citizens to operate in the foreign international jurisdiction of the sea. We say that the federal corporate franchises operating as states of states under the Uniform Commercial Code are exactly like franchises of Burger King or Wendy's or Target or J.C. Penney or IG Farben and have no sovereign nation state attributes. They are not and do not represent the continental state of America. This is important because these franchises operating under names like State of Ohio and State of Texas have no governmental authority and no public fiduciary capacity, and no public office related to the continental United States. They are merely using deceptively similar names and wielding what appears to be public office for their private benefit. We say that we and our parents and grandparents and our states on the land of the continental United States are not the states of citizenry whose good faith and credit was pledged as surety, benefiting the bankrupt United States of America, incorporated by the so-called Conference of Governors on 6 March 1933, and that such governors were never authorized to represent us nor our assets upon the land. This is important because we were mistaken on purpose as the same as, as federal United States corporations operated under names like the state of Washington and James Clinton Belcher, a foreign citus trust registered by the same state of Washington Incorporated. As a result of this false claim and venal semantic deceit, our private property and our assets were improperly subjected to their corporate bankruptcy as sureties without our knowledge or consent. We say that all that the governors attending the Conference of Governors on 6 March 1933 could pledge was limited to the assets of the federal corporation state franchises established circa 1868 and operating in each organic state of the continental United States as business enterprises and service delivery organizations. Their additional deceitful creation of franchises operated under our individual given names did not create any value vested in those franchises, nor constitute any valid pledge of our assets. This is important because all the credit and assets collected from American state citizens and extracted from the states on the land by creditors and bankruptcy trustees acting under false pretenses from 1934 to today are due and owing to the actual entitlement holders. We say the Federal Reserve Banks running the bankrupt United States of America incorporated as a bankrupt pass-through purposely advance vast sum of credit based on our assets and those of the continental United States to the perpetrators of this fraud scheme in exchange for establishing unseen bonds and maritime salvage liens against us and our private property assets. This is important because it establishes intent to defraud us and our actual states on the land of the part of the Federal Reserve. The Federal Reserve had already used semantic deceit based on similar names to pass itself off as a governmental agency and had bankrupted the United States of America Incorporated, together with all its similarly named state-of-state franchises. The misuse of foreign citus trust named after us was just part and parcel of the overall fraud designed to entrap our assets and our actual state's assets and access our combined credit for the benefit of the perpetrators. We say that our given names were presents given to us by our parents, and all names of use we have adopted as trade names as artists, bricklayers, musicians, writers, engineers, and others engaged in lawful and unregulated occupations are all our privately held intellectual property without exception. This is important because the fraud
practiced against us by the international banking cartels in the 1920s and 30s is now a very familiar crime. Identity theft. They literally stole our names and created legal fiction personas named after us, which they then claimed to own and control. As long as they could maintain the resulting illusion caused by the similar name connecting their make believe corporate persona to use and to our actual estates, they could plunder at will. We say that these false usufructs, the members of the Congress acting as officers of the private commercial corporations involved in also acting as members of a foreign government under commercial contract to provide us with a stipulated services seized upon our property, including our names, and stole our identity and our assets and our credit under conditions of fraud no different than any hacker or credit card snatcher. This is important because the facts of the matter must be established and related in a way that people understand. This fraud scheme was complex and long-term and hidden by veils of semantic deceit and constructive fraud carried out over decades. It was carried out on an unbelievable scale, but it all reduces down to common fraud gambits. We say that the Federal Reserve banks unlawfully converted the private bank accounts of millions of Americans into corporate accounts, technically belonging to the corporate franchises merely named after living Americans, and that the banks and governmental services corporations have knowingly colluded in this fashion since the 1930s, as evidenced by the still unheard charges brought by Congressman Louis T. McFadden, then co-chairman of the House of Representatives Banking Subcommittee before the House Judiciary Committee, and by the physical evidence seen on every personal check these banks issue. A close examination of the signature line on every check reveals that it is not a line but a row of micro print endlessly repeating authorizing signature or similar words. These words cannot be seen with the naked eye, and they are purposely obscured to hide the fact that the bank accounts have been seized and the banks have unlawfully converted private bank accounts into accounts belonging to federal corporations franchises without disclosure. This is important because it establishes criminal intent to defraud and deceive and presents prima facie evidence of it. Congressman McFadden's unanswered charges show that he recognized the criminality and tried to expose it. The microprint on checks reveals similar intent to conceal and defraud. We say that this circumstance requires the unprejudiced observer to believe that hundreds of millions of Americans are knowingly and willingly agreeing to operate as franchises of the United States Incorporated and to be owned as chattel by the United States Congress per the repugnant Act of 2 February 1871, 41st Congress, 41st Congress, 3rd Session, chapters 62, 63, 64, 65. It also requires such an observer to believe that Americans have been knowingly and voluntarily donating 100% of their earnings and retirement of savings accounts to franchises of a governmental services corporation operated by international banking cartels, and that the same Americans willingly and knowingly obligated themselves to do this for no credible reason at all. This is important because preposterous premise required to explain the circumstance exposes the fraud. All private bank accounts in America have been unlawfully converted to the ownership of IMF franchises, merely named after us. This has been done without our knowledge or consent. We say that personage and enslavement has been outlawed on a worldwide basis since 1926, and that press ganging on land assets into international jurisdiction of the sea and inland piracy have been both recognized as capital crimes for centuries. The banks fronting the government service corporations responsible for their practices in the modern day are crime syndicates. The politicians who colluded with them committed fraud and treason and crimes against humanity. Anyone claiming that these acts undertake as a result of war or under war knowingly taken these venal actions against peaceful non-combatant civilians via mischaracterization forbidden by the Geneva Convention Protocols of 1949, Volume 2, Article 3. This is important because we must clearly state the harm that has been done to us and the severity of the crimes committed, whether they are considered as civil crimes, crimes of morality, or crimes of war. We say that all titles to land and other private property have been secretively converted to the state of state franchises in the same way the land patents belonging to the American state citizens in continental states are being held under color of law and used as chattel because backing the debts of successive governmental services corporations. The United States of America Incorporated and its franchises styled like this: State of Florida. The United States Incorporated and its franchises styled like this: States of Alaska, and now looming on the horizon, the United States of America Incorporated and its franchise styled simply like this: Ohio, Florida, Wyoming, and so on. This is important because the fraud is ongoing with no end in sight, and nothing but increasing criminality and violence on the horizon as the perpetrators prepare for another round of fraud against the public.
We say this circumstance requires the unbiased observer to believe that millions of Americans have knowingly and willingly and voluntarily given away the benefits of their true trust land patience for social benefits, which they have then paid for themselves with their own labor and private enterprises, then also knowingly and voluntarily agreed to lease back their own land and pay rent on it to foreign banks and their corporate franchises instead of possessing it in fee simple, all to benefit commercial corporations whose only business is to provide 19 enumerated services to us that we could otherwise provide ourselves or which we could easily contract out to other service providers. This is important again because the absurd premise exposes the fraud. No one in their right mind would agree to the deal just described. We say that real estate titles benefiting the state of state franchises of the United States of America Incorporated, or the state of states franchises of the IMF doing business as the United States, or the Federal Reserve doing business as the United States of America, or their corporate franchises doing business
as Ohio, Alaska, etc., are all held under color of law and are null and void for fraud upon the unsuspecting American people since 1933. This is important because color of law is being used to enforce fraudulent maritime salvage liens against actual land assets across America. We say that in addition to these frauds, seeking to redefine people as various forms of legal fiction corporations, a crime known as personage, and in addition to placing undisclosed and unjustifiable maritime salvage liens against the land holding of the continental United States and the American state citizens, the perpetrators have sought to destroy the meaning and sanctity of marriage and family by extorting people to obtain marriage licenses under the false pretense of government mandates and the creation of civil marriage contracts, which secretively reduce marriage to a commercial business contract in which the state franchise claims a repugnant veiled interest, to wit, to own the products and proceeds of the partnership formed, living children, businesses, homes, and estates. This is important because this vile deceit results in de facto enslavement and repugnant claims of commercial interest in living people and their most sacred relationships. We say that the corporate commercial state franchises have used this undisclosed commercial civil marriage contract as the basis of their ability to distribute jointly held private property and divorce settlements into the side issues of child custody and to impose vicious and self interested fines and fees upon non custodial parents and to make unreasonable and unsupported demands upon custodial parents. This is important because it demonstrates the way in which these undisclosed and deceitfully imposed commercial contracts are used as means to exercise arbitrary control over parents and children and family assets that do not belong to any bank or foreign state or state. We say that the bankrupted United States of America, Incorporated, operated by the Federal Reserve System, and the United States Incorporated, operated by the International Monetary Fund, colluded to further pillage and enslave the American people by the imposition of a federal income tax overtly placed upon corporations as a corporate privilege tax, but then misapplied in Massey to individual people and private property via personage and barratry and false presumption that we willingly and voluntarily agreed to operate as federal United States corporate franchises, DC municipal franchises, and now United Nations corporate franchises. This is important because IRS claims are the result of these same criminal fraud schemes perpetuated by mostly foreign-owned banks acting in violation of their charters and the public law. Living Americans are not corporations. They don't occur accrue income. They are not liable for an income tax nor obligated to perform as withholding agents for any corporate franchise named after them. Yet millions of Americans have been jailed under these false pretenses, harassed, robbed at gunpoint, and defrauded of their time and their actual private property. We say that hundreds of millions of Americans have been harassed and defrauded and enslaved and reduced to peonage and kidnapped and press gangs into foreign jurisdiction and imprisoned for a profit by these monsters in suits who have taxed them for the privilege of supposedly donating their private property, their time on earth, and their labor, their land, and their businesses to service corporations run by banking cartels. Those operating the United States Congress have appropriated fat salaries and fatter retirement benefits, excellent health insurance coverage for themselves while pretending to represent the victims and the lawful government established by the American people in the continental United States. Proof of their perfidy stands upon the public record as their oath of office. Members of Congress take their oath to the United States, not the United States of America. This is important because without a public office and a properly executed public oath, nothing these charlatans say or do has any valid effect upon the land or the people of the continental United States. Everything they have said and done is null and void with respect to, to us and applies merely to themselves and their own corporations, for which they are 100% liable. We say that we have fully documented this circumstance for state and United States district courts and for high-ranking elected and appointed officials, governors of states, and United States secretaries of state, and United States secretaries of the Treasury. We have documented it for the Joint Chiefs of Staff and members of the British Embassy and high-ranking clergymen in churches from Salt Lake City to Rome, and yes, even the Pope. This is important to establish our due diligence over a period of years from 1998 to today. We have worked tirelessly to fairly inform those responsible for the continuing fraud and criminality. We say that the only individuals representing the high contracting powers who to our certain knowledge honored their office and took immediate action to correct the situation are the Popes Benedict XVI and Francis. This is important because when confronted with obvious fraud and criminality, hundreds, if not thousands of people in positions of trust failed to act, which has resulted in ever increasing criminality and violence. We say that we fully informed various courts acting for the state of Alaska, including the Supreme Court for the state of Alaska, and the Superior District Courts for the state of Alaska, and the Superior Court for the various courts acting for the United States, the United States District Court, and the United States District Court, the U.S. District Court, and the United States District Court, and the District Courts of the United States, all via United States certified mail, all are documented, and none of them honored the law in spirit or in fact. This is important because it demonstrates the incorrigible criminality of the Bar Association and their members and their failure to investigate and address the misadministration of their courts. We say that absolutely all of these courts representing the United States of America Incorporated and the United States Incorporated and now the United States of America Incorporated and their parent corporations, the Federal Reserve, IMF, and United Nations, have in our direct experience avoided and dishonored both the actual public law and the published public policies of these various commercial corporations, and have even dishonored the state franchise statutory law, a codified private law law form based on the lawful states statutes, which they deceitfully misrepresent as public law. They have ignored Uniform Commercial Code UNCITRAL, the Universal Declaration of Human Rights, the Universal Right of Self-Declaration, the Liber Code, and the Geneva Convention Protocols of 1949, they have not even bothered to obey their own rules and have plunged headlong into open criminality, fraud, force, and plunder. This is important because it demonstrates the willful criminal intent and misconduct of the Bar Association membership in a wide variety of settings, running the full gamut from federal district courts to county courts. We say that we brought this circumstance to the attention of the Federal Bureau of Investigation and the Alaska State Troops and the United States Marshal Service, and none of these law enforcement agencies did anything to bring charges or arrest any of the perpetrators of this fraud and pillaging. This is important because it demonstrates the complicity and ineffectiveness of these agencies as anything more than competing commercial mercenary forces. We say we contacted multiple employees of the Office of the United States District Attorney and provided evidence of wrongdoing and fraud on a massive scale. They did not respond to our letters or our sworn affidavits. It is important because it demonstrates criminal neglect and willful refusal to perform in the public interest. We say we contacted the Office of the Inspector General and got multiple form letters stating that our issues involved matters outside the scope of their duties. This is important because it demonstrates criminal administrative negligence and failure of oversight protocols. We say that we contacted numerous members of the United States Congress and documented the entire history of this circumstance and cited examples and evidence of interstate bank fraud and securities fraud and gross abuses committed by the IRS and the Internal Revenue Service and the foreclosure fraud against living constituents. We fully informed them of the facts. They took no action to correct or remedy. This is important because it demonstrates willful complicity and tacit approval of fraud, violence, racketeering, and extortion. We say that beginning in 2011, we objected to mortgage contracts we autographed in good faith in the 1990s before we were aware of the facts presented here. We acted throughout via special appearance as third-party interveners. This is important because we never granted the court any consent to address us in any other capacity or role. We say that we took action under American common law in the land jurisdiction in accord with Article 7 of the actual Constitution. This is important because refusal to adjudicate disputes affecting us and our land assets according to the common law of the Alaska state is denial of our guarantees and violations of both Article 7 and the Uniform Commercial Code, which preserves the same guarantees at Section 1 through 308. We say we contacted the local public notary to execute the necessary due process. She faithfully mailed and held each step of the due process action, and the purported mortgage lender Roswell Properties never replied. In June 2012, the public notary, an officer of the court who fully witnessed the proceeding in common law and controlled the process so that nobody could complain that any part of it was tainted or improperly executed, issued declaratory judgment in our favor. This is important because our effort to resolve conflict was pursued in the proper jurisdiction, witnessed and administered by a disinterested officer of the public court, and resolved by acquiescence in any honest court. This would have been the end of the matter. We say that we notified the Superior District Courts for the state of Alaska of the Superior Court's findings and that the due process common law declaratory judgment was ignored. The attorney representing the plaintiff was allowed to continue her attacks against various legal fiction personas operated under our given names in the foreign jurisdiction of the sea. This is important because the attacks continued even after the claim was settled in the proper jurisdiction, and even after we objected to being mischaracterized and misaddressed as corporate entities. We say that the Superior District Court for the state of Alaska deliberately continued in the face of rebutted false presumptions, despite admitted lack of in personam jurisdiction, and despite lack of evidence that we ever signed anything as corporate officers or consented in any way to their proceedings. This is important because it demonstrates willful disregard for the most basic tenets of actual law and provides prima facie evidence of criminal wrongdoing. We say that the land jurisdiction of the United Colonies of America and the continental United States and the several states thereof guaranteed by the Constitution of the United States of America was wantonly disrespected and violated. This is important because the proceedings were claims against land assets knowingly made in a foreign jurisdiction by officers of a private corporate tribunal pretending to be a public court and a judge pretending to have judicial powers while operating as an executor de suntor. We say that we informed the Supreme Court for the state of Alaska and requested that it intervene and provide guidance to the lower court without result. This is important because it demonstrates a collusion and fraud throughout the Alaska court system, Incorporated, and the failure of the Supreme Court for the state of Alaska to administratively correct the operations of the lower court is prima facie evidence that our demonstration case is not an isolated mistake or administrative error. We say that as third parties acting as interveners, entering special appearance as friends of the incorporated franchise defendants, we inform the Superior District Court for the state of Alaska of the fraud being practiced, and as the only sworn witness having firsthand knowledge of the facts and events resulting in the existence of our purloined promissory note and the fraudulent mortgage contract, we provide affidavits more than sufficient to convict the plaintiff plaintiff, the court, and its officers of multiple felony level crimes and fatal defects of administration. This is important because the court violated the rules of evidence and ignored the basis of its own deceits. It is also important because all parties concerned were given explicit instructions and were fully informed. We say that the Superior District Court for the state of Alaska entertained a parade of corporate personas, which were separately named and falsely accused as defendants or defendants during the course of the case 38 AN 126858 CI. Anna M. Riesinger, von Rees, and James C. Belcher, which was federal state level transmitting utilities, and Anna Maria Riesinger and James Clinton Belcher, which are a federal municipal estate trust, Anna M. Riesinger, von Rees, and James C. Belcher, which are municipal transmitting utilities. This is important because addressing the same complaint to so many different corporate personas demonstrates prima facie evidence of a deliberate contrivance employed with willful intent to defraud. We say that the case First National Bank of Montgomery, Minnesota versus Jerome Daly, known as the Credit River decision, established res judicata and stare decisis, and all similar cases and did so by jury decision in the superior courts of the people, which no inferior court or jurisdiction has authority to overturn or review according to the Article 7 of the Constitution for the United States of America. This is important because a jury decision in public court stands over any decision by a corporate administrative tribunals, which are expected to act in conformance with public law. We say the Jerome Daly case proved that the Federal Reserve banks and other lending institutions organized under their system never give anything of equitable value in exchange for the promissory notes and mortgage contracts that they obtain. This is important because once such a determination is made by a jury, it stands as fact. We say that Jerome Daly forced a bank manager to admit under cross-examination that the bank created the funds it loaned to Jerome Daly out of thin air simply by entering numbers in a ledger and which represented credit already owed to Jerome Daly by the same banks. This is important because it demonstrates that the basic fraud process. The banks create the credit they loan out of thin air simply by entering numbers in a ledger, and that credit is based on the borrower's own assets, not the bank's. The bank loans nothing of value of its own. We say that the bank manager and the Daly also admitted that this was the practice throughout the Federal Reserve System. This is important because virtually all banks in this country are members of the Federal Reserve System. We say that there is no excuse whatsoever for foreclosure action that has been taken in America since 1968 in favor of the banks and lending institutions operating under the Federal Reserve System, nor any successor system operating under the same principles. This is important because the Daly case The Daly case proved that no equitable consideration was given by the banks and no valid contract ever existed as a result. We say that the United States Small Business Administration that obtained the promissory note and mortgage contract in case 3AN 126858 CI and the Superior District Court for the state of Alaska was operating as part of the Federal Reserve System and using the same exact procedure as the First National Bank of Montgomery, Minnesota in the Daly case. This is important because the Daly case was already decided that there was no obligation to prove the same facts again. We say, as the only sworn witnesses having first-hand knowledge of the facts, that no actual cash ever traded hands in the transaction discussed throughout case 3AN 126858 CI, and that the United States Small Business Administration received our promissory note without disclosure of its value and without disclosing its own status as a false storefront for undisclosed banking interests. This is important because the bank knowingly misrepresented itself as a government institution offering a federal disaster loan and obscured both its nature and identity. We say that undisclosed to us, our promissory note had actual cash value equal to the entire amount of the purported loan and was redeemable for cash at any United States Treasury window. This is important because it establishes the motive for the bank's deceit. They were able to obtain funds equal to the entire amount of the loan from us without our knowledge. This enabled them to deposit our own funds in a bank account and write a check off those funds back to us, thus creating the illusion that they gave us a loan of their own assets. We say that other than providing the only actual asset which underwrote the entire transaction, we received nothing but peonage from the banks and the state in exchange. This is important because if we had acted as employees of the state or the bank, they would have had to pay us for our services as builders and caretakers of their property. They would also be responsible for paying any taxes or other fees. This is important because their failure to pay us and failure to pay the taxes owed provides prima facie evidence that they were never the owners of the property. We say that more than 40 years after the Daly case established the fraudulent nature of mortgage loans, this same fraud is occurring every day throughout America. Additional information and publication obtained from the Federal Reserve banks themselves has confirmed that the same practices that led to the Credit River decision are ongoing today. This is important because it proves that ongoing systemic fraud and usury is being practiced by banking institutions throughout America. And far from addressing the crime, the bar associations, law enforcement agencies, and administrative courts are aiding and abetting it. We say that as a result of this fraud and racketeering, we have suffered extortion under armed force and loss of over $228,000 United States dollars and private credit and an estimated 100,000 United States dollars in actual private property loss and usage deprivation, and have been evicted from our home by armed commercial mercenaries masquerading as police officers. This is important because millions of people are suffering in the same way and for the same reasons. Private corporate tribunals acting in conflict of interest and pretending to be public courts, executive administrators acting as executioners, de Suntor, and claiming to have judicial powers, banks loaning the borrowers own sets to them, armed commercial mercenaries pretending to be policemen. We say that on 17th November 2014, armed mercenaries wearing uniforms, impersonating actual police officers but instead representing the state of Alaska Corporation, trespassed upon our posted private property and physically evicted us from our land on the basis of orders from a judge employed to act for the same corporation and acting under all the same false pretenses we have described. This is important because this gives us standing as injured parties and witnesses directly and physically harmed by this fraud and violent racketeering. We say that the man who trespassed upon our private property to evict us was wearing a state of Alaska trooper uniform and carrying a sidearm. He was fully informed that he was trespassing and that neither he nor the judge nor the court issuing such orders had any right, jurisdiction, or authority to be present on our land or to address us about any matter at all, and that he was committing a grand felony level property crime as well as a capital crime of inland piracy. This is important because he was fully informed and warned. We say that he pleaded the Nuremberg defense and stated that he was just following orders and didn't know anything but the words on the paper in front of him that was signed by a judge. This is important because it is prima facie evidence that the people enforcing this fraud are being misled about the nature and authority of these so-called judges who are private corporate employees and not public officials at all. We say that we questioned this man and asked if he knew the difference between a state of Alaska trooper and, an Alaskan state trooper, and if he realized that he was functioning as a commercial mercenary and as a police officer. He shrugged and appeared helpless. This is important because it is prima facie evidence that this man didn't know and wasn't being informed of his lack of authority by his employers, which resulted in him unknowingly undertaking criminal acts of trespass, grand felony armed theft, inland piracy, and assault. We say that we would have been well within our rights to shoot this man and those who accompanied him in defense of our own lives and property. But we realized that he and his companions were ignorant and deliberately misinformed and had no idea that they were acting as criminals and in behalf of criminal syndicates. This is important because there are a great many people who might, under similar circumstances of criminal assault, fire upon armed trespassers acting as commercial mercenaries, and they would be justified in doing so. We say that this circumstance and these conditions are a direct result of criminal usur- usurpation against our lawful government carried out by incorporated banking institutions and governmental services corporations that have no right to exist when they are operated as crime syndicates. This is important because foreign governments have chartered these corporations and allowed them to run amok on American soil. We say that it is self-evident upon the public records of the past 150 years plus the documented experience we bring forward that these banks and governmental services corporations have operated as criminal syndicates. They have done so they have done so despite determined and documented objection. This is important because it demonstrates continuing willful intent on the part of these organizations to commit felony level crime against the public. We say that similar fraud and misadministration committed by the Internal Revenue Service and the IRS has resulted in millions upon millions of innocent Americans being harassed, fined, and even jailed for long periods of time for the crime of not paying taxes that they don't owe, can't owe, and never owed. And again, it is rooted in the crime of personage, pretending that living people are corporations. This is important because it ties in with all the other fraud. We say that the courts responsible for these and similar actions throughout America are criminal syndicates, knowingly practicing personage and barratry and purposefully mischaracterizing their victims and misinterpreting and misapplying private statutory law for corporate profit and individual gain. They are looking innocent American. They are looking innocent Americans in the eye, full weak, well knowing that these living people are the priority creditors of the corporations they work for, and they are sentencing these same innocent Americans to prison terms for not accepting peonage, press ganging, fraudulent conveyance, inland piracy, forced evictions at the hands of private mercenaries, harassment, personage. I already forgot. Barratry, racketeering, and armed extortion. This is important because these vile and self interested acts are being carried out by our employees acting in ignorance and by people who are here under the conditions of a treaty and corporate charter they are violating. We say that slavery and peonage and press ganging have all been overtly outlawed for nearly 200 years, and that these continued misrepresentations resulting in the enslavement and press ganging of living people and their private property assets is repugnant capital and felony level crime that is not being addressed by those responsible. We have addressed the Bar Association themselves and the various British and American court officials without result. This shows our due diligence via certified correspondence issued over a period of years and demonstrates that the Bar Association members and leadership of the various court systems are willfully pursuing felony level crime on our shores. We say that no in house corporate tribunal, merely calling it a state court, has any authority beyond interpreting the internal policies of its own corporation and to discipline its own actual employees, and that the purposeful misuse of the word state to imply public function and authority for such a court is an obvious venal deceit.
This is important because the corporate tribunals, being run by professional members of the Bar Association, must be presumed to be aware of their limitations and to be knowingly violating them. We say that there is no statute of limitation on the crime of fraud, and that this fraud, which began as of 27 March 1861, has tainted all resulting debts, contracts, and agreements and representations made by these commercial corporations pretending to represent the Republic and the people of continental United States. This is important because longevity of this crime has no effect upon its time prosecution once discovered. We say that the federal United States has never represented the continental United States in any matter apart from those responsibilities specifically delegated by the original Constitution contract. This is important because it allows us and the rest of the world to begin sorting out what these miscreant employees and false usufructs have done in our names without granted authority. We say that the vast majority of the individuals who currently occupy what appear to be public offices throughout the continental United States have taken no valid oath of office and have no public bond or fiduciary capacity related to the continental United States and the American state citizens inhabiting them. This is important because individuals have been occupying vacant public offices and abusing them for private gain and appearing to take action, finding public resources and affecting American state citizens without any authority to do so. We say that the Patriot Act, National Defense Authorization Act, and other constitutional repugnant acts undertaken by members of Congress apply only to citizens of the federal United States and to their own corporate employees and cannot be foisted off onto the continental United States and American state citizens. This is important because the federal United States has attempted by force and fraud to press gang American state citizens and to lay claim to the assets of the United States on the land of the continental United States under color of law and false pretenses. They have depended upon the ignorance of their employees to provide enforcement, as already demonstrated. We say that all varieties of federal state of state corporations have no right to continue to operate on our shores outside defined federal enclaves and are not allowed to use public facilities belonging to the Alaska states and other states of the continental United States so as to confuse people and assume the identities of the states on the land. This is important because these private for-profit franchises of bank-owned governmental services corporations have occupied public buildings and pretended to be and or represent the actual continental states, while in fact operating in a different and foreign jurisdiction. This is another aspect of the fraud and identity theft that must be addressed and corrected. We say that the people and the states operating the land jurisdiction retained for themselves all powers not directly and explicitly ceded to the federal United States. That includes the right to control all federal military and agency personnel operating on our soil. The Joint Chiefs of Staff have been directed under the civil authority of the continental United States to recommission the Grand Army of the Republic and to prepare to take action to protect the living inhabitants of the continental states in the event that
the renegade Congress and the president continue to make improper claims upon us. This is important as it demonstrates the seriousness of the situation and the need to take action to protect the public and the peace from banks deploying commercial armies under the guise of being federal agencies. It also exposes the same danger to the United States military that they could be misused in the same way. We say that Western states, which have been organized under statehood compacts, are owed immediate recognition of their land jurisdiction and receipt of all original patent to land resources within their geographic borders, and that the living people born in these geographically defined states at any time since they entered into statehood compacts in good faith are American state citizens known to be peaceful inhabitants of the land of the continental United States. This is important because the public peace and stability of the region depends on fully honoring the statehood compacts. We say that the living people and the geographically defined states must be set free of any presumption of debt or encumbrance related to the federal United States and its criminally misadministered governmental services corporations. This is important because these entities have prolonged fraud against their employers and benefactors, as demonstrated by the entire content of this affidavit. We say that all members of the federal United States military and law enforcement agencies are under known and public contracts and treaty to protect and defend the people and the assets of the continental United States, and that the Joint Chiefs of Staff have been issued competent general civil orders under the last man standing rule to disarm any and all federal agencies, FBI, CIA, FEMA, BATF, NSA, DHS, BLM, etc., and to prevent these agencies from being employed as commercial mercenary forces, and to arrest any corporate officer, including Barack H. Obama, who initiates any armed action whatsoever against the people of the continental United States. This is important because anyone taking a paycheck based on the labor and other assets of American state citizens either owes their good faith service under contract or they act as criminals subject to arrest and prosecution. This includes the President of the United States Incorporated and members of Congress operating as corporate officers. We say that federal state of state officials are operating as undeclared federal corporate officers and that they have no valid contract to administer or lease or control any asset of the land jurisdiction of the continental United States. This is important because private corporation officers are engaged in constructive fraud and are impersonating lawful public officials and exercising public authority for private gain. We say that just as we were never informed of these nefarious bankruptcies and false claims, hundreds of millions of other Americans were never informed, as we were self-interestedly presumed upon, so were millions of others. This is important because we have only now become fully aware of the enormous crimes of the banking cartels and governmental services corporations and bar associations, and able to rebut the false claims being made as a result of this con game. We say that we are owed a full and accurate accounting of all assets of the land that have been conscripted managed or otherwise controlled by any federal agency or corporation, including the United States Department of Defense, and that each American is owed the proceeds from all bonds issued in their names and the interest from all investments, generally plus the mortgage payments they have made in error on all homes and private businesses, plus the credit balances collected as abandoned funds, capital credit accounts, and insurance and indemnity accounts created and operated under their given names, and that we are likewise owed a similar accounting of all public assets conscripted by the federal United States and rightfully belonging to the continental United States. This is important to set the records and accounts straight so that the country as a whole can make a clean start. We say that the problem that now faces us and our world has been largely caused by the failure of those responsible for the jurisdiction of the sea and to honor their solemn obligations owed to all nations everywhere. Control of our individual estates on the land and restoration of our purloined credit and peaceful, unopposed restoration of our lawful government on the land is not subject to negotiation. We don't go to war with corporations, we fire them. This is important because corporations are legal fictions that exist only by agreement and for beneficial and lawful purposes. We say that we contributed our faithful labor to improve the land we are heir to, and to build sound homes upon it, and to drill good water wells, and to establish plantings of trees and flowers and vegetables and useful herbs. In so much as we are able, we have preserved the land from disaster, damage, or pollution, and have promoted its physical beauty and biological health. We say that we are entitled by birthright to the enjoyment of the land we have improved in this manner without claim or interference from any other individuals or any incorporated entity on earth, and that preservation of such peaceful enjoyment of these and other natural rights are the only reason that any government has a reason to exist. This is important because it establishes the basis of our claim in natural law and attaches it to the Declaration of Independence. We say that as we demonstrated by allowing ourselves to be evicted under armed threat rather than harm other innocent people, and yet have continued our strong nonviolent objection and determined action to end this fraud and criminality and to reclaim our rightful property assets. We encourage everyone to keep calm and go forward from here. There are only 515 people who are directly responsible for the operations of the federal United States, and only the members of the Congress are accountable for the Washington, D.C. municipality and its criminality. This is important because it demonstrates our will to keep the peace and treat these matters as crimes and treaty violations. We say that instead of looking at our differences, which only serves the criminals who skillfully use differences of religion and culture and skin color to divide and conquer us, we must retrain ourselves and our children to sneak out our similarities so that we are never duped into war for profit again, never mischaracterized again, never defrauded in this manner again. This is important because it demonstrates the necessity of openly addressing systemic criminality It is only because we failed to do so in the past that these problems have festered and left us still dealing with issues of peace, jurisdiction, and slavery arising from the Civil War. We say that our only true duty is to nurture our planet and the animals and the rest of mankind, as it was when Genesis was written. It remains to this day. This is important because it attaches our claim and our will to the most ancient source of all law of the land, the torch, and clearly shows the intrinsic, the intrinsic criminality of all those who destroy our peace and our planet. We say that poverty is caused by robbery, for whenever we find that people have been robbed of their time or their resources or their credit or their good names or their hope. People worldwide have been robbed by those they trusted and had reason to trust: their own teachers, doctors, preachers, lawyers, judges, bankers, kings, presidents, Indian chiefs, and elected officials who have grossly abused their position of trust and gotten away with it precisely because they occupy positions of trust. This is important because those who assume positions of trust owe an ethical and fiduciary responsibility to all the rest of us, and that obligation must be enforced. We say that the actual problems we face are not caused by any of the scapegoats offered up by the corporate propaganda machine. We must fix our attention instead of thousands of ignorant local officials on sheriffs and military officers who don't know their duty, on dishonest lawyers and judges, on bankers who steal us blind, on doctors who show no true concern for health, immoral religious leaders, and criminals in political offices are the real enemies we have to worry about from Boston to Bangkok. This is important because we can't fix a problem or seek justice until we define what it is and what it is not. We are now finally in a position to do so. The problem doesn't lie with any of the innocent average people trying to live their lives in peace and take care of their small bit of the planet. It lies with criminally minded megalomaniacs using corporate structures to defraud the whole world. We say that we are setting the history of this massive fraud scheme, all verified as true upon the public records, and placing this affidavit of truth and probable cause before the members of the United States Congress who are directly and uniquely responsible for these deplorable lies and repugnant claims made against the American people they claim to represent. The President of the United States Incorporated, the Joint Chiefs of Staff who are hired to protect us, and all those law enforcement officers who are drawing their pay throughout the world while allowing all this fraud, usury, violence, peonage, enslavement, and piracy to go on and on and on. This is important because although we have given them all fair notice of this criminality before, they are now receiving notice from the American public served up in front of the whole world. We say that we are likewise placing this affidavit before Pope Francis, Her Royal Majesty Queen Elizabeth II, all heads of state, all senior members of all world governments, all members of the United Nations, and the Secretary General thereof. This is important because everyone on earth deserves to know what to know that the popes messed up, but are now trying to correct that the British monarch continues to be uniquely responsible for this mess, and that all the presidents and chancellors and heads of state are fiduciaries being called to account for the condition of our world, whether they took the proper oath or not. We say that we are placing this affidavit before the officers of the World Court, the International War Crimes Tribunal, the Roman Curia, the Vatican Chancery Court, the British High Court Chancery Division, and the United States Supreme Court via this extremely public affidavit claiming violation of our natural rights, violation and plunder of the national trust of the United Colonies of America, the United States Trust, and violation of the Supreme Perfecto Republican Declaration of the United States Colonies of America, and criminal violation of individual state trust, the Treaty of Paris, the Treaty of Versailles, the Treaty of Ghent, the Treaty of Westminster, all British Admiralty treaties owe to the land jurisdiction of the continental United States, commercial and administrative default upon the Constitution for the United States of America, giving rise to the existence of the federal United States, violation of the land jurisdiction of the continental United States, violation of the Alaska Statehood Compact, and insomuch as the perpetrators and their organizations are members of the United Nations and obligated to its charter and declaration, violation of individual human rights guaranteed by the Universal Declaration of Human Rights, including the universal right of self-declaration, violation of UNCITRAL, and violation of the Geneva Protocols of 1949, including Volume 2, Article 3. This is important because those responsible for this state of affairs died long ago, and those presently administering the train wreck cannot answer for it short of being gibbeted, which attaches our will and claim to the law of love in the mercy seat of justice, such that all those who now realize their errors and who turn away from them and assist in making due correction are to be held harmless and not held subject by this affidavit of truth and probable cause to any law but the law of love. We are requesting permanent protective injunctions against the federal United States, the IMF United States Incorporated, the 50 state franchises, the Washington, D.C. municipality, the United Nations Incorporated, the Federal Reserve, and the 50 state corporations recently set up by the new Federal Reserve and doing business as Ohio, Nebraska, Idaho, and all their franchises. We act in the public interest and in behalf of ourselves and the Alaska State and all those living people naturally inhabiting and belonging to the land jurisdiction of the continental United States. We claim all assets of the continental United States, all trust, utilities, copyrights, patents, franchises, subdivisions, municipalities, land and assets of the land held in trust, insurances, inheritance, stocks, bonds, securities, mortgages, titles, and profit derived from the assets of the continental United States and from our own assets, including our labor, and we will a just and proportionate like interest to all those who have been born on the land of the continental United States, and who are owed both their private and public property interest returned and set free and clear of fraudulent debt claims, and conveyance, including all deeds and titles to land and land assets held under color of law by corporate franchises operating deceptively as states of states and under the given names of living people, release of all mortgages and other dubious maritime contracts, and salvage liens tainted by fraud, return of all promissory promissory notes obtained under conditions of non-disclosure and semantic deceit and sentimental of all debts held against us, our 50 geographically defined states, and the land jurisdiction and assets of the continental United States in favor of one, the living inhabitants of our own private estates, and all similar states of living people inhabiting the land jurisdiction of the several states on the land. Two, the Alaska state and similar states geographically described and having actual substance. And three, the continental United States as a whole. We solemnly affirm that this affidavit is true and confirmed by abundant public records and corroborating testimony beyond responsible doubt, and we present it for the good of mankind and in the public interest for the recoupment of property and controlling interests rightfully owed to us and our countrymen by the federal United States and the colluding international banking cartels and the governmental services corporations and municipal corporate franchises that have violated our trust and their contracts, and for no other reason or purpose. We act as living beings, naturally belonging to the land jurisdiction of the continental United States and acting thereon without any privilege of incorporation and desirous of none, under penalty of perjury, should we be found to have knowingly erred or purposely obfuscated any fact herein presented. Here are our autographs and our seals presented by the flesh and in the flesh and in our own right, without the federal United States, without any corporate office, without representing of any kind, being witnessed by these other living souls who are all present in the flesh, standing upon the land jurisdiction of the continental United States, and whose autographs and seals similarly appear as witnesses before the courts of the world addressed and summoned, and before 7 billion people worldwide, all of whom have been harmed in some respect by those who have committed these crimes and perpetuated these acts of fraud. That was the final chapter. Well, I should actually say the final part of You Know Something Is Wrong When, an American Affidavit of Probable Cause by Anna Maria Riesinger and James Clinton Belcher, which was also illustrated by Paul Allen Snover. Thank you for sticking with me to the end for this, and hopefully I will see you next time.